It's my honour, actually, and privilege to come to the university again to talk about my favourite subject in one of my favourite places. So thank you very much for the kind invitation. I was here in November at the forum that was organised, and I was astonished, really astonished by the quality of the research that's going on here. And anything I can do to assist you all and the university in taking these ideas forward and commercialising them, it's my duty to do it. But IP is always in the news, but actually the last few days have perhaps demonstrated more than usual just how important IP is. You can't have been unaware that in the last 2 or 3 days stock markets around the world have been crashing, falling very, very quickly. I think America had the biggest fall for years. In London, certainly, property prices have been falling quite steadily. You try and put your money into a bank, you get a really terrible interest rate. So if you've got lots of money, if you're an investor, what do you do with it? The answer is that you try and put it into businesses that are going to bring some kind of return for you, and they tend to invest in intellectual property, whether that's in the film industry or the music industry, or whether it's investing in startups or funding through angel networks, all sorts of new technology, or whether it's investing in some type of business that has got a great reputation in the software or technological field. What you usually find when economies are plummeting is that intellectual property benefits, and I think you're going to see a lot of that in the next few weeks. In this talk, I'm going to start off at a very, very basic and a very, very simple level, and then very quickly, within 2 hours, get to quite a sophisticated level. It won't be too sophisticated, but it will go quite quickly. I'm very happy, if you are, to take questions as I'm going along, but I've got a very strict 2-hour window. So if you ask me a question, please make it a question, not a statement, because I can't then respond to it quickly. But I will stop for questions if you want me to. Okay? So without further ado, everything you want to know about intellectual property, but we're afraid to ask. I'm going to start off by looking at what intellectual property really is, because I suspect it isn't what you think it is. Look at some of the justifications for protecting IP. Look at the types of IP and what you can and cannot do with it. Look at some of the restrictions on dealing with IP in particular. Then start looking at commercializing IP. Look at some case studies from UK universities on IP policies. The UK is my area of expertise, so that's why I've chosen UK universities. Look at successful cases of spin-offs from leading UK universities, and then look even deeper at specific case studies from Oxford, Imperial, and from Cambridge. So what is IP? Well, I've called it the property in creations of the mind, such as technical inventions, literary artistic works, software, designs, symbols, names used in business. But the subject matter of IP is incredibly broad. It's not one subject. It's a combination of different legal rights which together have this generic term, intellectual property. But copyright is very, very different from patents. Trademarks are very different from designs. And yet, even though they're all very separate, there are times when they all come together. And just because you can't get a patent for something, it doesn't mean you can't get trademark or design protection. So you need to understand how it all fits together. I've been in the world of IP since the mid-1980s, and I've yet to meet any business that didn't have intellectual property. Every business, every academic institution has intellectual property. They may not realise it, but they do. And even when they do realise it, they don't realise just how much of it they've got or what they can do with it. Intellectual property, when I first heard the term, I thought it was some kind of property that only intelligent people could actually use. But that's not what it is. It's property that comes from the mind. That's why it's intellectual. And it's a fundamental concept that certain byproducts or things that evolve from human creativity should be protected, and we'll look at why that is in a moment. We all know examples of physical property: your house, a car, the contents of your house, your personal belongings, my watch. They are items of physical property. You can hold them, you can touch them, you can take them apart. But intellectual property is property that resides here and is protected. So it's what comes from your mind, whether it's expressed in the form of a book or a song or a film, whether it's expressed as an invention or a design or a logo, or whether it's a trade secret. These things that come from the mind are protected in law. And even though some of these rights have been around for some time, it's really only in the last 20 years that there has been a real understanding and appreciation of what an IP does and how it can be used. And actually, the European Union has been one of the pioneers in doing this. So, why should intellectual property be protected at all? There are some people who would say you shouldn't bother to protect it in the first place. Well, I'm an IP fundamentalist, and I can think of 6 reasons why you can protect intellectual property. And I think it's important to understand these so that it then enables you to understand why it is protected and why it's important that what you do is recognised and commercialised. The first justification is what I call unjust enrichment, and my source for this is the Bible. The Bible says you should reap what you sow. Apparently it's in Galatians. So you should not reap that which you do not sow. What this means is that it's unfair or unjust for someone else to take the benefit of your creative endeavours. And that's why, for example, we protect someone's song from being copied, or protect someone's invention from being copied. Second justification is what I call natural rights, and this is very boring and very philosophical. But there was a chap called Locke who came up with a theory of property in 1690. And the idea is that whenever anyone mixes the products of their mind with things that are already out there, the commons of ideas, this should be protected and made their own property. So you're taking an existing state of affairs and adding to it to create something new. But the problem with this theory is, well, how do you value your contributions compared with what is already out there? That's not easy to do. Third justification is personality theory. Intellectual property is the representation of an individual's personality. I have some difficulty with this theory, but it's important in some areas. You know, if you say to a songwriter or a poet or a novelist, is what you produced a representation of your personality? Of course it is. You know, these people produce work because they feel it. I say in the music industry, music is how emotions sound. You know, you don't get paid to write a song because you're getting paid for it. You want to express yourself. It's different, however, when you're looking at patents or research or trademarks. But that's another justification. You need to compensate someone through retaining their personality. Fourth is human rights. Many people don't realise it, but intellectual property is a human right. In France, copyright is not called copyright. In France, copyright is called droit d'auteur, the author's right. In France, and in some countries in Europe, intellectual property is seen as almost as important a human right as the right not to kill or be killed or anything else. In common law countries such as England, it's seen as a property right. But if you look at the international human rights documents, you will see that intellectual property is protected. And in Article 2, Protocol 1 of the European Convention on Human Rights, there is a specific reference to IP, and there have been cases where stealing someone's intellectual property has been seen to be a breach of their human rights. It's quite dramatic, actually. The social contract. The social contract, I think, is the best reason for protecting intellectual property. And what it says is that in return for making a contribution to society in some way, whether it's through a wonderful song or a lovely design or a great invention or recognizable logo to signify a badge of origin, you should be rewarded by the state for that contribution to society. And what you will see is that the state rewards different IP rights in different ways, but the general principle is the same. I like this because you can then straight away see a quid pro quo. And then the last one, which I won't pretend to understand fully, is the economic arguments. But I've read really very, very dull books on explaining why intellectual property can be justified on economic grounds. The main and obvious conclusion is that IP needs to be privately owned. I say that again, intellectual property should be privately owned because it provides incentives to the creators to produce further IP. As soon as you start nationalising IP or putting it into the public sector, that incentive disappears. And with that incentive, so do the ideas disappear. So privatising, keeping IP personal, is actually very, very important to enabling more of it to come. Okay, that's a justification. IP rights are either, and this is very, very basic, registered rights or unregistered rights. If they're registered, they are registered either with a national authority, or you can register your IP rights, depending on where you live, in a regional body. So if we're in the UK or in Cyprus, you could register your design or your trademark either in your local country, or you could register it at the European Union Intellectual Property Office, which is now Alicante in Spain. And with patents there are slightly different provisions, but the principles are the same. But just because your intellectual property right is not registered, it doesn't mean you don't have that right. All it means is that it's perhaps not quite as easy to enforce that right as if it was a registered right. Some rights only exist nationally, some exist throughout a region. In designs, for example, you can have designs that cover all of the EU, or designs that's just local. And the EU has completely changed the face of intellectual property law. And Cyprus is still catching up. And it's not surprising, there's so much of it. But the idea is that most intellectual property laws around the European Union should be harmonised, so that the intellectual property laws in Portugal should be the same as Estonia, should be the same as in Cyprus. Generally, and I do say generally, Cyprus confers the same rights as those in the UK. It's important to realise that the UK and Cyprus have a very similar legal system. It's called the common law legal system. And this means that even though all of Europe's got the same rights, the way that they will be enforced and practiced and dealt with in Cyprus should be the same as in the UK. But that is different from how they will be enforced and practiced in Greece or France or Germany, where they've got civil law systems. And that's a really important distinction which the EU has still not come to terms with. When the UK leaves the EU, it'll make it a bit easier, but it's an important distinction. So, what else? Main IP rights. Hopefully you've come across these terms before. You will very shortly. Patents, copyrights, databases, designs, trademarks, trade secrets, confidential information. Those are the main categories of IP rights. In this talk I'm going to focus much more on patents than the other IP rights, simply because I think that's of most interest to you. But if you want me to go into more detail about any of the other rights, very happy to take a question. So, patents. Patents are very, I'm sure some of you have got patents, they are very complicated documents. And to make things worse, they are also complicated by differing procedures, which have different fees and different processes and different places you apply to. In Cyprus, there's specific legislation that deals with patents. for Cyprus, but Cyprus is also part of many international conventions, and it's unusual to apply for a patent from Cyprus and do it in different ways. But a patent provides protection for any new invention or any new process. So this is the social contract in its most obvious form. So you come up with a brilliant invention that's going to change the face of mankind. You come up with a cure for the common cold. In response, the state will give you a limited monopoly so that only you can exploit that invention. But it's a limited monopoly, it's 20 years. And because of that, not everyone wants a patent. To get a patent, and this is the same everywhere in the world, you need to satisfy 3 tests. The first is that your invention or process is new. Now that has a very specific definition. It means that it must not form part of the prior art. That is to say, it has never been done or disclosed anywhere before. Because if you think about it, going back to the social contract, if someone else in Japan has already come up with a cure for the common cold, why on earth should the state reward you, who's done exactly the same thing, with 20 years monopoly on it? It doesn't happen. This first point is called novelty, but I've used the word new here, is the most likely place where you will trip up in your attempt to get a patent. Because someone else has done it. You may not realise they've done it. On Friday in London, a client of mine came to me and said, I've come up with a new way of creating an engine, a combustion engine, that's going to run on air, not on petrol. Well, that's very interesting. I don't know enough about this, so I've got someone to check for me. He said to me, no one's ever done it before. I thought, fine. We did a search, patent search. There were over 1,200 patents that have been granted in respect of engines that worked on the same principle. He didn't know about any of them. Perhaps he just didn't do his homework. But the point is, how are you going to know what's been done in Korea, or what's been done in America, or what's been done in South Africa? You know, you do not get a patent that's been done before. Secondly, there has to be what's called an inventive step. So it mustn't be an obvious invention. Usually you can satisfy that test. And then the third is that it's capable of industrial applicability. Even if your patent can be applied industrially, it doesn't mean that anyone's going to be interested in it. There are thousands of patents that I've come across which are perfectly valid and properly granted, but they're completely useless. Why do they not want it? So let's look at novelty. This is probably the most important 2 or 3 slides you're going to see, because this is where you may go wrong. So an invention is new if it does not form part of the existing state of the art. So I'm going to read this out because this is very important. State of the art in relation to an invention comprises any matter, whether a product, process, information or anything else, made available to the public before something called the priority date of the invention. Publication includes usage and written or oral disclosures, but excludes a disclosure made in breach of confidence 6 months before the filing date. Now what this means is that once you've created an invention or a process, you must be very, very careful not to tell people or to show them what it is that you have done. Because if you start giving lectures about it, or if you write articles in academic journals about it, or even if you tell the wrong people about it, you may have been deemed to have disclosed the invention. And if you've disclosed the invention, it forms part of the state of the art. And if it forms part of the state of the art, it cannot be new, which means you will not get a patent. And you have to be incredibly careful how you go about it. Also, unsurprisingly, it won't be new if there's any other patents out there, or a patent application even. So if 2 people at this university at the same time are working on the same invention, and one of them applies before the other one, the second to apply will not be able to get a patent protection because the other one's application will have formed part of the state of the art, depending on where it is in the process, and that will then prevent them from getting an argument that it's new. And an unpublished invention does take priority. However, this is so important, I put it in red in block capitals. Please, if you remember nothing else about today, just remember this. An inventor can disclose it themselves and destroy their own ability to get a patent. So please, if you're thinking of getting a patent, do not go out telling people, do not go out giving lectures, do not go out writing articles in academic magazines. Do not show it to prospective businesses unless you've got a confidentiality agreement, because you will then destroy your ability to get that patent. There are lots of ways that you can, lots of steps you can take to avoid early disclosure. Don't exhibit or publicly use an invention before filing the application. Ensure that any person who works with you on the invention, possibly a manufacturer who's going to create prototypes for you, make sure that they sign a confidentiality or a non-disclosure agreement to prevent them from disclosing it in breach. If they do, if they breach that confidentiality or non-disclosure agreement, even though technically it's part of the state of the art, the law allows you because you did everything you could to prevent it becoming public. And if you've got any marketing agreement, make sure it's got a confidentiality clause so that the marketing people don't go around disclosing your application. Courts apply an objective two-step test to determine novelty. The subject matter of a patent will form part of the existing state of the art and will not be new, if the earlier patent discloses information that if performed would necessarily result in infringement of the earlier patent, or provide sufficient information to enable someone to operate the invention. You know, if you created a time machine and you said to someone, "I've created a time machine," that probably wouldn't be, a disclosure which will prevent you getting a patent, because okay, how are they going to go and copy your time machine if they don't know how it's done? But if you said, "I've created a time machine, here are all my mathematical, physical formulae and calculations, and this is how I do it, and this is how I deal with this issue," and you give them sufficient details so they can say, "Well, thank you very much," and they go off and do it, that is when you get the state of the art. So very, very, if you're going to say anything to anyone, do it, if you have to, in the vaguest of terms. Don't go into any detail at all. So that's novelty, it was step one. There's 3 steps, there always seems to be 3 steps in everything to do with IP. The second step is inventive step. An invention, to be patentable, must have what's called an inventive step. It's got to be something that is not obvious. It's an objective test. The invention must be deemed inventive in the eyes of this fictional person, who is a person who is skilled in the art. The law, especially IP law, loves fictional persons. There's a man on the Clapham Omnibus, for example. There's the reason of the man. Not many people exist. I came across once the man in the pub. That was an actual test, the man in the pub test. But this one is someone who's skilled in the art. So someone who's got some knowledge of the industry or the sector must conclude that this is a genuine breakthrough, must be inventive, not obvious. And the courts follow a 4-step test, usually, which I won't bore you with because it is very boring. But inventive step you can usually satisfy, because you won't even get to talking about a patent unless you thought it was inventive. The industrial applicability point, something can be patented but still be of useless or no value. And I put Company X case study, which was a case I did about a year ago, where this company, client of mine, it had somehow managed to get 4 patents, European patents from Munich, and they were all to do with mobile phones. And they all looked really interesting and groundbreaking. They were basically technology to make sure that if you dropped your mobile phone, it wouldn't smash and you could still use it. But none of them ever took off. None of them had any commercial value at all for various reasons. So they had all these patents, they paid a lot of money for them, but they were meaningless. And I suppose the message there is only look at the time and cost of getting a patent if you really think it's going to be useful, because people go and get a patent because they think, oh, I must have a patent. But you know, you don't always need a patent. Coca-Cola. Coca-Cola, I think, was invented in the 1880s, something like that. What is the formula for Coca-Cola? Does anyone in this room know? No. 4 people apparently at any one time know the formula for Coca-Cola. I'm told by people that seem to know that it's got vanilla in. That's what I've been told. But no one actually knows for sure. And the reason that no one knows for sure is because they've never told anyone. If in 1880, whatever it was, they had gone and got a patent in the US, they would have had a 20-year monopoly, but they would have had to produce in the patent application complete the list of the ingredients, great detail as to how they did it. So when the patent expired, everyone would go and use the same ingredients and combine them in the same way and create a product which was identical to Coca-Cola. Now I love Coca-Cola. No other cola tastes the same in my view as Coca-Cola. None of these zeros and diets and all these other rubbish things. Coca-Cola is Coca-Cola. No one has ever been able to replicate the taste. But everyone would have been able to do it had they had that patent. And that's a great example of not always getting a patent. But some things you can never patent. It access over the laws. You can't patent an idea. There must be a physical or a tangible expression of that idea to get a patent. To the mathematicians and scientists here, I'm afraid you can't patent a discovery or a scientific theory or a mathematical method. They are protected in other ways, but not through patents. You can't protect them through a patent in aesthetic creation, like a song or a film or a book. They're protected through copyright. You can't protect schemes or rules or methods for performing mental acts or playing games or doing business. I've put in purple computer programs because this is such a touchy area. When I was at university a long time ago, I had to write a dissertation on how to protect computer software in IP law because there was no laws on it at the time. And although it's settled now that you protect the computer program from copyright laws, it's very, very uncertain still to the extent to which a patent will protect a computer program. Now, I don't think most of the time you actually need a patent for a computer program because computer programs change so quickly anyway. Why would you want 20 years protection? It's meaningless after 2 or 3. But still, you can, and you do get to see patents in the areas of some kind of business applications. I mean, a good example is, I think, the fuel injection system in a car. You cannot get a patent for the software that makes the fuel inject, or whatever the fuel injection system does. I'm not an expert on it. But if the consequence of that software development is to create a technical effect elsewhere, i.e. to make the car more efficient or to run better, you can then get a patent for that, because the law allows you to protect software where there is a technical contribution. As a general rule, and it's a very general rule, it's much easier to get a patent for software in America than it is in the EU. So if you've got some software and you want to patent it, if that's the decision you come to, don't look at Cyprus, don't look at the EU, look to the US. Getting a patent, if anyone's ever had to do it, is very, very complex, expensive, difficult, takes a long time. There are 4 routes for obtaining a patent from Cyprus. There's something called the European Patent Convention, which is an international treaty which covers European states but not the EU states, so it's broader than just the EU states. And for that one you make an application to the European Patent Office, which is in Munich. There's something called the Patent Cooperation Treaty, which is a worldwide international treaty of 160 states. You make one application somewhere, and then you nominate the countries that you wish to be protected in. Because you won't need a patent in every country in the world. You may want a patent for EU, US, China, Japan, Russia. Forget the rest of the world. So you nominate the countries. There is something very, very new called the European Union patent, which is a patent that's granted by the European Union. I'm less keen on this one for many reasons, because it doesn't really add anything to what you've got under the European Patent Convention, but it exists. And then there's the Cyprus patent, which is, with no disrespect, a bit meaningless, because you're not going to want a patent that's just for Cyprus and for nowhere else. Patents are territorial. I should have said this, I'm sorry. A patent is territorial. If you have a patent in America, it's only effective in America, so you can exploit it in China. So what you do is you start off in one country, and then you nominate other places that you want to be protected in. I've said the EPC, I've said the Patent Cooperation Treaty. The Patent Cooperation Treaty is always what I'd recommend. You start off in one application, there are various deadlines along the way, but it's cheaper than applying in each country separately. So rather than applying for EU, America, China, Russia, you might get an American patent and then extend that to EU, China, Japan, whatever. Right, I'm going to stop for 1 second. Are there any questions on patents? Good. Copyright, much more interesting. Oh, okay.
Yes, something please. The European Patent Office is the one you listed as European Union patent? The ones that, the applications that are direct to European patent?
There are two patent systems with the word European in. The European Patent Convention, which is the one that has been around for a long time, you make the application in Munich. That one is the one which has been in existence for, I think, about 40 years, I think. And it's a very good system. The European Union patent, like all things to do with the European Union, is absolutely deluged in bureaucracy. And it hasn't helped by the fact that the UK was meant to be responsible for the dispute resolution system of the European patent, and then we decided that we weren't going to be part of Europe. So that has complicated things a bit. I personally would avoid the European Union patent. I would always seek protection through the European Patent Convention or the Patent Cooperation Treaty, the international treaty, but designate the EU as a state, as a place. Copyright. I find copyright.
One question. Sorry, again on the territorial rights. So, if for example you copy a patent that's valid in the UK and you implement it in Cyprus, and you have someone who comes over to Cyprus and they buy a product, will they be able to use that product in Cyprus but not use it in the UK?
Yes. Yeah, because it depends what the act of infringement is. Because you infringe any IP right in a number of different ways. One of them is copying it, one of it is importing it, one is distributing it. It depends what restricted act or type of infringement they have committed. But if in Cyprus you have done something which is covered by a UK patent, but only a UK patent, you are not infringing by doing that act in Cyprus. If you do that act and you produce a product, and that product is then sold in England, it might be an infringement of the patent because you've imported something that embodies the patent, but usually the patent is the process or the invention that creates the physical product. It's not the physical product itself. Okay. So it depends. So I'm trying to think of a good example. So
if you sell something to tourists, for example.
This sounds like a personal story coming here. Yeah, so you sell something to the tourists.
So you sell something to the tourists.
For example.
And Cyprus is perfectly legal, right? Because it's not protected.
Well, it depends what it is.
Let's say it's a phone, for example.
A phone?
Yeah.
Okay, so a phone is patented only in England, you're saying?
Yeah.
Okay.
You manufacture in Cyprus, you sell it to tourists.
Yeah.
Cyprus is perfectly legal. If those tourists take their phone and they go back to the UK, Would that be infringing?
No, because they're not infringing the patent. They are in possession of a phone which has been manufactured in infringement of the patent by someone else. So you ask yourself, where has the wrongdoing taken place? The wrongdoing has taken place, I would argue, in your scenario, in Cyprus. It's not a wrongdoing to be using the phone in England. Another example,
it's not a wrongdoing because it's not protected in Cyprus, right? The patent was filed in the UK for the UK.
Well, that's right. It's not wrongdoing in your situation. If I was acting from the right side, if I was advising the manufacturer, I would say, in which countries do you think there is a risk that your intellectual property or the products of your mind could be used? They would say, well, there's all these bloody tourists go to Cyprus. There's a risk that Cyprus. So I would say, fine, make sure that your patent is extended to cover the territory of Cyprus. A very specific situation is to do with copyright, we're coming to now. But copyright, Cyprus has got a terrible reputation for pirate films, and in the past it used to be pirate music. You know, when I was younger, I used to come to Cyprus and go to a record store in Magariou, and they give me a cassette. I'll buy a cassette, blank cassette, and they say record any albums you want. After that, I became head of the music industry's anti-piracy unit in the UK. I have practical knowledge. But you see there, the wrongdoing occurred in Cyprus because that's where the copying took place. The fact that I was listening to it at home in England wasn't wrongdoing on my part. And a very current example is with Kodi boxes, you know, where or any device designed to get round subscription for copyright services, because those services, the wrongdoing takes place where the product is actually sold and it's bought rather than where it's used. So if I bought something in Cyprus that was illegal in Cyprus and then used it in England, the wrongdoing has happened in Cyprus. So it's a very important question you've asked, and we'll come on to it in a bit more detail shortly. But whenever you're planning an IP strategy, you have to work out where the wrongdoing or where the risks are to your business and close those off. Okay, copyright. You can see I like copyright. Copyright to me is the most interesting intellectual property right because, first, it's the oldest. It's been around since 1709, the Statute of Anne in England. And secondly, copyright is an incredibly flexible legal instrument, and your copyright always finds a way of protecting new innovations. You know, originally copyright protected literature, and then it started to protect art. Then it was expanded to protect music. And then when technology took over in the early 20th century, it was expanded to include sound recording, so what record companies did. And then when radio came along, it protected radio broadcasts. And then it protected television broadcasts. And then it protected films. And then when the video cassette came out, it protected video cassettes. And then when DVDs and CDs came out, it protected DVDs and CDs. And then at one point it protected designs. And then when computer software came along, yet another incredible innovation, it was copyright law that was used to protect computer software. And then we had this thing called the internet. Now, you know, it's obvious now to all of you that when content is used through the internet, copyright law comes up with the answers. But I spent probably 2 years between 1997 and 1999 traveling around the world to explain why copyright was the best vehicle to protect any rights through the internet. And in 2003, the European Union agreed and passed this directive, and so now it's accepted that any use of content through the internet is protected by copyright. But that's the beauty of copyright. It always seems to be able to protect things. And the beauty of copyright is that you don't need to register it. It arises automatically. And copyright protects just about anything you can think of. You know, so if in doubt, say my work is protected by copyright, because there's a good chance it will be. Because you don't have to prove you registered it, and it protects just about everything. But it protects literary works, academic texts, for example, software, databases it protects. It protects artistic work, so I'm talking now to university context, academic drawings, diagrams, flowcharts, it protects all of that. It protects songs, it protects recordings, you know, it protects plays, it protects films, it protects sound recording, it protects typefaces. If there was no copyright laws, there'll be no music industry, no film industry, no broadcasters, no newspapers, no magazines, no artists, no computer companies. Virtually, society will ground to a halt if there was no protection of copyright law. And the EU has been trying to harmonise throughout the EU copyright law for 3 decades now, since about 1988. And they've harmonised the laws in a number of areas. So prior to 1994, each member of the European Union protected copyright for different periods of time. As a matter of policy, copyright law is meant to protect 3 generations of a family. So for a long time, the protection was life plus 50 years, because they thought that someone's entire life plus another 50 years would cover 3 generations. But some countries in Europe, namely Germany, had a longer period of protection, life plus 70. So another 20 years was added in the mid-1990s to protection. And this created a really strange situation in many countries where works have gone out of copyright and then came back into copyright. So one day you were able to use something without infringing copyright, and then next week you were infringing because there was another 20 years protection added. This is where I mean it gets very, very complicated. But most areas of copyright are now harmonised at the EU level. And the good thing, from Cyprus' point of view, is that it means that the copyright laws in Cyprus are pretty similar to those elsewhere. Infringing copyright happens in a number of ways. Reproducing a copyright work means copying, distributing a copyright work, arranging a copyright work, publicly performing, broadcasting or communicating to the public a copyright work, that's with the internet. All of these, if you do it without a license, is a copyright infringement. There's an area which I won't bore you with called secondary infringement, which is where you're not doing it yourself, but you're authorising someone else to do it. You may be familiar with some of these. There are lots of exceptions and defences to copyright infringement. Educational exemptions, so certain things done through academic institutions or schools are exempt from copyright infringement. Fair dealing means that you're given the right sometimes to use other people's copyright material. Temporary copies, I mean that's quite an important point, and it's an area where copyright law has had to evolve because of technology. But the computer experts here amongst you will realise this, but when you copy something on a computer and then send it, there is a cached copy that remains on the computer, it's stored somewhere, and there could be a temporary act of copying which occurs for technical reasons. That is technically an infringement of copyright. As a matter of public policy, the law says something that you do for the purpose of a technical purpose rather than because you want to make commercial use of it should be an exception to copyright infringement. Incidental inclusion is where you've used someone's copyright as part of something else. So, for example, there's a RIP broadcast on the results of the presidential elections in Cyprus, and in the background there's a song by the Rolling Stones playing. Now, they have no control over what music is being played at a presidential rally. Had they infringed the copyright in the Rolling Stones song? No, because it's incidentally included. However, if they had made their own broadcast, if they had made their own programme, a review of the election campaign, and they put this music to associate it with the programme, that's different, not incidental. Parody I love. Parody is where you are making a joke out of someone's copyright situation, and it's not an infringement of copyright in certain circumstances to make a joke of someone's song or literature or whatever. Right, we've done copyright in 5 minutes. We're going to go into designs. Designs is the most complicated area of IP, I think. Oh, sorry, you got a question?
Can I have a question? How do you prove your copyright?
How do you prove the copyright? And I imagine you're asking because you don't register it, is that right?
Yes, I mean...
okay, I need to explain this. Forgive me, because you've only got 2 hours, I am going quickly, so I'm not saying some things I should, so you did the right thing.
If it takes long, we can answer it.
No, this is a very quick answer. With the registered rights, you get a piece of paper that looks like this, which says patent XYZ in your name, and you wave that and someone knows that you own the rights. It's the same with a trademark, a registered trademark, and the same with a registered design. With copyright, it's an unregistered right, so you can't prove it with a piece of paper. The way it works is that there are a series of tests set out in the law by reference to a person's nationality, and they have to be part of a particular convention, and also by reference to how you created it. So if ever you're challenged, you would be required to show that on a particular date you had done this and someone else hadn't. It was difficult in the pre-computer days. Now it's not difficult, because your computer automatically creates a record of when a particular document was created, and you've got a computer audit trail which you can follow through. And so if in 6 months' time I lay claim to something which you did today, you turn around to me and say, well, I wrote this, here's my computer, it shows that on the 7th of February 2018 I produced this document. GNUGJUST 6 months later produces an identical looking document, but it wasn't done at the same time.
Well, I don't think it would work this way, because you can treat computers. It's not the...
Okay, it's not the only means. I mean, in the music industry, for example, the way you prove that you own the copyright, I always say to people, is make a recording of what you did and send it back to yourself through registered post. And don't open the registered post envelope, because there you've got the state effectively sanctioning what you have done. You can take it further, you can go to a lawyer and get the lawyer to produce what's called a statutory declaration, which says that I, Mr. GNUGJUST, saw this person come into my office with this document, a copy of it's attached on this date, and that in itself would help. And actually there are some informal registries as well, so you don't usually have problems. The only time it's ever arisen with me was many years ago when I was doing an anti-piracy case in England, and there was this guy selling bootleg counterfeit CDs and cassettes at a market in London, and his defence was that the artists had given him authority to do so. So he was actually saying to me, and he actually did say, bring Bob Dylan to court in Swansea on a Monday morning to confirm that he didn't give the licence. It was actually in that same case where the man in the pub test arose. But the judges are not stupid. That they would say this is ridiculous. Under English law, I don't know the position under Cypriot law, there is a presumption of ownership. So if you say you own the right, copyright, people will have to show that you don't own it rather than you show that you do own it. And you usually get around that problem. But it is complicated with copyright because there is no formal registration. It's not difficult to do, but you have to go through a series of tests. Industrial designs. Industrial designs, in England, there are five different legal regimes for protecting designs. All you need to know is the following bits. Anything that's in 3 dimensions that is new and has what we would call individual character can be protected either under Cypriot law or under EU law as a design. If you register it as a design in the EU, you get 25 years protection. If it's unregistered, you get 3 years protection. But the key issue is that the EU design regime is designed to protect the aesthetics of a 3-dimensional object. So these chairs, for example, I mean, they're quite attractive looking. They probably are protected by design laws. If you've given some thought as to how something is designed with reference to the materials, the texture, the contours, the lines, colour combinations. All of that is relevant to protecting, and it protects the fashion industry. So the way the fashion industry protects a lot of its garments now is through design laws, because it's the best way to do it. Again, I won't bore you with the details, but protecting designs through copyright law was the norm until about 30 years ago. Now it's design law. There's an overlap between designs and copyright, and also with trademarks. So sometimes you may go to a lawyer and they will say to you, well, you can't get copyright protection for your three-dimensional object. And that's it, because all they know about is copyright law. But you may find you can get the protection you need elsewhere through possibly design law or trademark law. Trademarks, everyone knows what a trademark is. What I can tell you, hot from the press, is that the trademark laws of Cyprus are being amended, and a new trademark law will come out in the next few months, hopefully, which will be fully compliant with EU laws. That is good on one part, but also the EU laws are quite complicated. But a trademark is something that identifies a good or a service as being from a particular source, and differentiates some person's goods and services from another person's goods and services. So, if I said to you Coca-Cola, you would know that I don't mean Pepsi-Cola. You know, you think of Coca-Cola as being that one, Pepsi-Cola being that one. In Cyprus, you may even think, well, Coca-Cola is the one that's in that place, Pepsi-Cola is the one in that place. And that's what a trademark does. It differentiates your goods and services from those of another. But in the old days, trademarks only protected names and logos. But in the last 20 years, it's been expanded. So now trademark laws also protect shapes. They protect smells. They protect slogans. So Carlsberg, probably the best lager in the world, is a slogan. That's a trademark. One of my clients owns all the rights in the Rubik's Cube. The Rubik's Cube is a trademark, a three-dimensional trademark, as is the Coca-Cola bottle, very distinctive. If you saw a bottle in that shape with no liquid in, you'll say that's a Coca-Cola bottle. You wouldn't say that's, you know, some other beer. The best trademarks are completely fictitious, invented names that mean nothing. Kodak, Nike, Polaroid, Adidas, Coca-Cola. Cyber, Cian. You know, they're good names, you know, and they're worth protecting. When you have a registered trademark, you get a 10-year initial monopoly, but you don't have to renew it. And it's worth renewing it, because a trademark you can have forever and ever. So long as they keep renewing it, no one else can call their Coca-Cola. And there are all types of international treaties on trademarks, which mean that you can protect it worldwide. Quickly mention trade secrets and confidential information. The laws protect trade secrets and confidential information. Nothing specifically in the law, but because it's a common law thing, they do. And databases are protected separate now from copyright as well. In the old days, a database will be protected through copyright laws, but the EU amended the laws so that there was specific protection for databases. Who owns the IP? General rule is that the first creator or author of the IP is the first owner. This is actually a very important point, because you don't always realise that you don't own the IP. You think you own the IP, but you may not be the owner. Any intellectual property that's created in the course of employment belongs to the employer.
I have a question about this. This depends from the country.
Sorry?
Depends from the legislation in the country.
Yes,
there are some
countries.
There are
yes.
Some countries where this is not.
I'm sure that's correct. Yeah, but you're 100% right. Although the general rule still, I think, is that an employer owns the IP. The big distinction, which is important to get from Cyprus and the UK, is the employer owns the IP, but if you're not technically employed, so if you are just some kind of consultant or some kind of freelance person, you're not employed, therefore you still own the IP. And the best example is when you get married and someone takes photographs of your wedding. You pay the photographer to take photographs of the wedding, so that's a fee for their labour. You also pay them perhaps to give you a book with certain photographs that you've chosen. That's part of the deal. But who owns the copyright or the IP in the photographs? Well, if you want other copies for your family, you find the answer out pretty quickly, because the photographer says that's going to cost you 200 euros, and it's because they own the copyright still. If they were your employee, you'd own it, but because they're an independent contractor who's done a job for you, they own it.
Excuse me. So we as employees of the university, we do not have IP rights to any of our inventions?
Yes, you do, but it depends what you've done and how you've done it. So, if you've created something that was part of your contracted or ordinary work, the chances are the university will own it. And we'll come on to this actually in the second half, and I'll look specifically. But let's say you're employed by the university to write computer programs all day, okay?
No, we're academics.
Well,
Okay,
let me just get to the point. But during the lectures, you actually write a song, which is a popular song in Eurovision. Who would own that song? That song would be yours because you're not contracted or employed to actually write music. You're employed to do something else. If as an academic you're employed to write computer software, and you write computer software, and you use university resource and university time to do it, the university will own it. However, where it gets more, but that's for copyright. When we get into patents, you get into a different conversation, because with patents, you then look at getting a patent and working out what the royalty split should be between the inventor and the academic institution. And in the second half, we'll look at certain universities in England, because that's where I know best, and you will look and see that different universities have a different approach to this question. But the general rule is that an employer in most countries will own the IP rights so long as you've used their resource, but it's not a fixed rule.
Just like to complicate this, we have a position for researchers here that is an unpaid researcher.
Yeah.
They are not paid by the university, but they do research work in the laboratories voluntarily.
Yeah.
What happens with IP protection if they discover something?
Are they an employee?
They're not paid.
Okay, if they're, well, first of all, you don't have to be paid to be an employee, but let's say they are not an employee.
There's no contract between them and the university.
You can have an employment contract with no payment.
But there is no contract, I'm saying.
Okay, all right.
At the moment,
If
the university will pay their insurance,
okay,
but there's no
if you
contract.
can show, okay, this is an employment law point. If you can show that someone is a genuine independent contractor and has been taken on to do a particular job, but not on a permanent basis with all the usual employment terms like holidays and salaries and agreements and all that rubbish, then they're independent contractors, so anything that they do, in theory, should be their IP. However, if they have used someone else's resource to do it, and they couldn't have done it without that resource, there will be a very good argument that actually the person who owns the resource should own the IP. I mean, I'm a boring lawyer. All these rules have exceptions, okay? But it will be more clear cut if, for example, you got on a 6-month basis a consultant from a different company to actually work with you to do this. In that situation, clearly the IP will be owned by the consultant, not by the university. But if the person was taken on the payroll and got a monthly salary and the holidays and all the other things, then if it was using university resource and was meant to be doing the job that he was paid to do, then the university will own it.
All right.
This is more relevant sorry, I'll come to you in a second. This will become more obvious in the second half, and I'm conscious we need to have a coffee break soon. When we start looking at specific university policies, because we'll then see how different universities apply this. Sorry.
Sorry. Just to go back to the photographer example that you gave, if the photographer still owns the rights to your photos, that means that he or she can sell your photos to someone else?
Okay. As if they really want to. The messages don't get married. There are other issues there. There's privacy issues. And so, you know, if you wanted to sell my photographs and put in Hello Magazine, and he got paid for it, there would then be an issue as to whether or not he was able to exploit my image and my rights to make money for himself. I've never come across that situation, but in theory what you say is correct.
If it's computer software or something else that it's not, there's no privacy issue.
Yeah, if it's computer software, so if I as an independent contractor write computer software for you, what you should have is a contract with me that says even though you own the copyright, you will transfer that copyright to me at a date in the future, or even if you keep it, I have a permanent license and you're not allowed to allow anyone else to use it. That's the way you control it. I think that's a good time for a coffee break. Should we have, how long should we have?
No, we can have a coffee break, but I had a question. Yeah, so at the beginning you said that, I mean, IP is a representation of individuals' personality.
Yes.
And then you talked about databases, right? And then we have all these free services that we get on the internet from Google, from Facebook, etc., which essentially, you know, the motto that if it's free, you are the product. I mean, so they monetize basically the personalities of billions of people.
It's a very good question.
So what is the, I mean, the regime there?
Well, it's a very good point. I mean, when I mentioned personality, it was as one of the 6 justifications for protecting IP. But I think that justification was much more relevant in the early days of IP, when IP was pretty simple, like copyright and songs or books or art. Now we're moving into a depersonalized world, which includes things like databases and computer programs and services you've been talking about. I think that theory becomes less relevant, actually. But what is certainly true is that all of these eventually, in some way, come back to the products of an individual's intellectual creativity. It may be that now you're protected by privacy law rather than IP law. So, should we have a coffee break? Yeah. How long would you like, Moses? I'll just deal with one question that came up over the coffee break, which something I didn't cover actually, and it's specifically with copyright. You can have lots of different intellectual property rights within one product, and that's important to realise, so that it's not this is protected by copyright, that's protected by designs, that's protected by trademarks. You can have lots of different IP rights in one product. So if you take a CD, a compact disc, there's copyright in the music, there's copyright in the recording of the music, there's copyright in the artwork. There will be a trademark in the record company name. There may be a trademark in the band name. There will be all sorts of patents in the compact disc, although they may have expired. Depending on how the compact disc is produced, there could be design rights in the actual compact disc. There could be an argument that there are trade secrets in somewhere in there. There could be databases, and there are all sorts of things. So what you have to do when you're advising someone is to look at the product and think about all the different intellectual property rights. When I did an exam on IP many years ago, we were given, as part of our exam, a packet of Love Heart sweets. And we were asked to advise on all the IP issues to do with those Love Heart sweets. And that was the most important and interesting thing I was ever asked to do at university, because it forced you to think about how you apply an IP. And that's why it's so important to talk to someone that really understands all areas of IP, not just one, because sometimes the answer is not in the obvious place. What can you do with IP? Well, IP, as we said earlier, is property. So you can do exactly the same thing with it as you can with physical property. The only difference is that you use different terminology. So if you talk about a house or a piece of land, you can buy it, you can sell it, you can let it, you can rent it, and you have expressions of freeholder, landlord, tenant. With intellectual property, it's exactly the same, but the words are different, which is where it gets a bit confusing. So you can purchase it, you can assign it, and an assignment is a sale document. So if someone says to you, I'm assigning my copyright to you, what they are saying is I'm selling my copyright to you. You can novate it, which is a very boring term. You can transfer, you can have a license. If you want to give someone permission to use your IP, but you yourself want to still own it, you give them a license, you allow them to use it. In the same way that if you want to keep ownership of your property, your house, but you want someone else to live there, they have to have a tenancy. Universities will most likely wish to license their IP. And I put here, beware EU competition laws. And the reason I say this is because there are very, very strict European Union laws that govern what any organisation can do when it's transferring or licensing technology. Because technically this could be a breach of competition law. So that's another day, that's another seminar, another course in fact. But just be aware that you've got to be familiar with European competition law rules when you're dealing with transferring IP. You see, there is a fundamental tension between owning intellectual property and competition laws. The EU wants to have a free and fair level playing field when it comes to competition law, but intellectual property laws give a monopoly to someone. So what do you do in that situation? The answer is that there is nothing wrong with the existence of monopoly rights, whether it's a trademark or a design or a copyright or a patent. The problems come with how you exercise those monopoly rights. So what you choose to do by having a monopoly. If, for example, in the pharmaceutical sector, you've got a wonder drug that's going to cure the common cold, but you don't make it available to anyone, or you make it available on such exorbitant terms that no one can afford it, or you price people out of the market, you run into competition issues. I mean, I'm not sure if it made it to Cyprus, but there was a very big investigation in England recently where they found a number of pharmaceutical companies have been setting artificially high prices for certain pharmaceutical products, which meant that people and the National Health Service were denied the ability to buy these products and make them available for the common good. So that was a competition law breach. So you just need to be aware of it. It probably won't affect any of you on a day-to-day basis. Right, commercializing IP. Wonderful to have IP, but really, you would quite like to make some money from it as well if you can. In my business, I mean, I have this strategy for commercializing IP, which was put up there. So you start off with some kind of basic health check that you carry out, or a detailed strategic review. If you're looking at a business, you make sure that their IP strategies align with their corporate strategy. You look at the risks from their use of IP or non-protection of IP. You register IP, you get the IP valued. You look at tax issues, you look at agreements. Having the IP is great, but you need to work out a way of doing something with it. I recently had a company which I was advising that produced this revolutionary formula for nail varnish. And they had patents just about every way you could think of, including places I had to look up on a map. I'd never heard of them. When I asked them, when I did one of these strategic reviews, I asked them in which markets they were most active. And two of them, they said, were very busy in Canada and were very busy in Brazil. We do a lot of business there. I looked at their patent portfolio, and when they had and trademarks, And when they had applied to protect certain countries, they had not protected either Canada or Brazil, but they protected all these places in the old Soviet Union, which they did no business in. My point there is that that IP was completely meaningless to them. What's the point of having a trademark which is enforceable in Kazakhstan if you're never going to do any business there? But why don't you have a trademark that could be enforceable in Brazil or Canada if that's where you're doing a lot of business? So you need to sort of be clued up and to sort of have a strategy. These are the type of documents that I produce as part of my work for clients, and from there we're able to assess their IP needs and hopefully plug the gaps. It's very important to register if you can, because if you register your intellectual property, it's worth more in all sorts of ways than if you don't register it. So to go back to the question you asked earlier about copyright, if you've got a registration certificate, it's much easier to prove that you own the IP right than if you don't. So if you can register a right, do so. So if you can register a trademark, do it. Don't rely on unregistered rights. If you can register a design, do it. But it's not always worth it because it's expensive, and sometimes you may not need to do it. Make sure though you ask yourself the question. Very, very important to get your intellectual property value. Even in England, which is a very, very sophisticated environment for IP, 94% of businesses have not had their intellectual property valued. Now you think to yourself, well, why would I need to value my IP? Well, it's property. You wouldn't dream of not valuing your house or your car or something else. Your IP is probably your most valuable asset, and yet it's not valued. I put 4 reasons there why they want to value IP. One is to raise security for finance. One is to value shares that you've got in the company. One is to obtain a good sale price for business. Another one is to obtain benchmark licensing fees. Without such a valuation, you don't know if you're getting a good price for what your what IP you've got or any shares you've got in that company. 3 ways to value IP traditionally. One way is to look at the financial contribution it makes, so you isolate the contribution of the IP to income and profit. Look at what's spent. It's called the cost method, but that's a bit useless, I think, that method, because let's say you build a house. It may cost you 50,000 euros to build a house, but it may be worth €1 million. So you can't say the house is worth 50,000 euros because that's how much it costs to build. And then there's historical transactions way of valuing IP, which is where you look to see what's been done in the past and how much people got for it. Right. IP universities. When you're talking about university, whether it's a researcher or academic or university itself, you need to first of all think about what intellectual property are we talking about. You have to go through the exercise I spent some time doing in the first half. You need to decide, are we talking about patents, are we talking about copyrights, are we talking about trademarks, are we talking about designs, are we talking about trade secrets? You've got to isolate what the IP is. Because until you do that, you cannot decide what to do with it. Because if you're talking about copyright, there's no point thinking, well, should I register it? Because you can't. If you're thinking about a patent or a design, you have other considerations. If you're thinking about, I've got an invention and I'm thinking about patenting it, the first thing you think about is, I must make sure I do not inadvertently disclose this to anyone else inadvertently discloses it. If you're thinking about a design, there's a 1-year period that you have before you can register a design. So you've got to have all these different things going around your head. The second thing you need to think about at university, which we discussed earlier, is who owns that IP. Just because the IP exists doesn't mean you own it. Someone else may have the difficult decision of what to do about it. And then the last thing is, what is the best way to commercialise this intellectual property? And there are all sorts of ways you can do it. What I've done is to look at intellectual property policies from selected universities in the UK, and just to give you a very brief headline overview of what they do. All of these slides, I think was said, will be available to all of you at the end, so you don't need to write anything down about this, okay? All of this is, or most of this I think, is publicly available on the internet anyway. So if it's something that's of interest, just look up the university and look up their IP policy. But I looked at 3, Edinburgh, Leeds and Sussex, because they're all sort of geographically disparate. I didn't look at the IP policies of Oxford, Cambridge or Imperial, because they are much more sophisticated and much more complicated. I think the Cyprus University of Technology recently produced a paper on ownership transfer and commercial exploitation of IP. But what I'm going to do is look at issues like ownership, royalty split and independent adjudication of disputes. I always think independent adjudication of disputes is much more important than it appears to be, because when there's a dispute, you want to make sure that you have an impartial adjudicator, not someone who's closely associated with one side or another. The general rule, and as I keep saying, it's a general rule, is that IP generated by employees and students of the university in the course of their employment or studying belongs to the university. That is the general rule. IP created by employees outside the course of their employment belongs to the employee concerned, except when the university resources have been used to create the IP. I mentioned this before the break. Edinburgh University follows that general rule, so that IP generated by employees and students belongs to the university. Leeds is much more liberal. If you look at Leeds' IP policy, which I've got here somewhere, it sort of follows a general rule, but it does it in such a way that it gives much more rights to the inventor. Sussex, again, is much more commercial. Sussex is a much more entrepreneurial, I think, institution than the other two. And so it creates a lot of incentives for inventors and universities to actually together go and make money. Again, I haven't got time to go through them in any detail. They're on the internet. Go and have a look at them.
Just a parenthesis. We've had for over a year a policy that's based on Oxford's one.
At the University of Cyprus, yeah. I know. But the Oxford one is only in terms of the IP policy. It's not, I think, covering things like spin-outs and startups in any detail. I think it's just to do with the policies of who follows what.
So legally, the university can't have startups that are
not yet.
co-owned from the university.
Not yet,
So
because
that's
it's a
why we
public
haven't
university.
covered that.
No, but hopefully that will change. Hopefully that will change. But at the moment, that's the position. That's correct. Interestingly, it's about, I think Cyprus is one of the few countries I've ever come across that has that rule, which in my view is completely artificial and obsolete, ridiculous. But it is what it is. I don't live here, I don't pay taxes here, so I can say what I want. And I think it's a completely stupid policy and it has to change. Anyway, Leeds takes a more collegiate approach. At Leeds, very interestingly, not all the IP generated by the staff belongs to the university. And it sort of goes to your point earlier. There are exceptions there, which I've set out. You can read them at your leisure. But there is no fixed rule. There are just general rules here. Leeds also confirms a general position that university is committed to sharing with the staff concerned the rewards derived from successful commercial exploitation of their IP. And that is a very, very liberal approach, which I don't think Oxford shares. Sussex follows the general rule, but does not claim its rights of copyright in books or articles for learning journals written by members of staff or students, which is unusual. So if you're at Sussex and you write a learned article in a journal, the university doesn't say it owns a copyright in it. Actually, probably the journal owns a copyright in it. But the researcher who wrote the article would have more of the same copyright ownership than the university. But it does claim ownership in all other forms of IP at Sussex, including software and distance learning materials. Again, you can read this at your leisure. Okay, what I've done is to look at royalty splits, university employees at some of these places. Edinburgh, you can see that the differences between where the royalties are up to 50,000 in blue and where it's more than 50,000 in green. But you can see that Edinburgh is up to 50,000. 50% goes to the inventor, 30% to the inventor's school, and 20% to the university. But if it's over 50,000, the splits become more equal. So it's 35,000 to the inventor, 35% to the inventor, 35% to the inventor's school, and 30% to the university. Edinburgh has very detailed processes for spin-outs. It's, again, not really relevant to University of Cyprus because you can't do spin-outs, but it gives you an idea of how best practice is seen in the UK. At Edinburgh, for example, the university has to prepare a case to set out why a spin-out would be the preferred route to exploit the IP. And it's a very, very detailed and actually quite a bureaucratic process. And then the case is evaluated by a panel convened by senior university staff and one external member who's knowledgeable about the industry and the sector. If the panel approves the formation of the company, it instructs the university to set up the company on certain terms and conditions. So there's quite a formal system there and a very well established route. Shares are, well, when it's set up, the company is usually on the basis that the equity holding at the outset belongs to the university and the founders of the company in a proportion to be agreed. But shares allocated to the university are often paid for by IP license to the company and the university. And the company doesn't normally take money from the university for those shares. More detail, all of this is taken from the IP policies on the internet, which is why I'm rushing through them, because there are things I want to cover, and this you can find yourself on the internet. Very detailed though, very sophisticated ways of regulating who owns what and what you can do with it. Edinburgh, as I said, is very, very detailed. Leeds is far less detailed. I mean, and that's the Leeds one. This is the Leeds policy of exploitation of IP. It's about 4 pages, I think. The Edinburgh one is it's huge. This is the Edinburgh one, much more detailed. It's more than double the length. Sussex is again more similar to Edinburgh, but you go to all the universities and they all get different policies, slightly different splits, but they all follow the same principle that the inventors should be rewarded. And as a general rule, the higher the royalties that come in from exploitation of the invention, the less the inventor gets. I think independent adjudication is very, very important. You know, with IP, there's an expression which we use, which is where there's a hit, there's a writ. And if something is successful in whatever area of IP, someone tries to take advantage of it or copy it. There's no point copying something that is unsuccessful. It's pointless. So you should expect disputes if something is successful. So let's say you've got an invention. Let's say it's been commercially exploited by a university that can do it, and let's say that the thing becomes very, very successful. Suddenly everyone wants more money from it. Doesn't matter what you've agreed, they'll always find arguments to disagree with it, or to say that this income shouldn't be taken into account for royalties. And accountants can come up with all sorts of creative arguments. So what you do is you have a detailed regime for dealing with those disputes. To me, this is actually probably the most important part, because unless you've got a reliable and accepted way of resolving these disputes, those disputes can actually poison the relationship between the inventor and the university and all the other parties, because everyone wants more than there is to go around financially. Right, examples of successful spin-offs. We talked about Oxford just now. Oxford does it through ISIS, which is a subsidiary company of Oxford University. And the way they do it at ISIS is that Oxford University acquires an equity stake in the company which is being set up or spun out in terms of art. The management of the equity usually falls within the remit of something called the Oxford Spin-Out Equity Management. And at an operational level, this entity provides support for spin-out companies, including managing formal consent rights, participating in the development of growth and exit strategies, getting access and investing. So it's a very hands-on role. Since '97, ISIS Innovation in Oxford have been responsible for creating these spin-off companies. What astonished me is that at Oxford they spin out a new company to develop the research every 2 months. That's phenomenal, actually, when you think about it. Those figures are slightly out of date now. It's now over 320 million. But over 320 million, I think, has been raised in external investment since 2000 as a result of investment from spin-out companies at Oxford. Of course, just to go back to basics, none of these companies would have any value at all had they no IP. Those companies only have a value because they have IP that can be protected. Which goes back to the slide I mentioned earlier, that the IP needs to be valued. And they channel, and the creation of these companies and the royalties they bring in channels millions of pounds back into the university in the forms of research, local development, and also creates jobs. Some success stories from Oxford. Oxford Instruments first spun out in 1969, Oxford Immunotech, Natural Motion, Adaptimuni. All of these are very, very successful companies out of Oxford. Oxitec is a very powerful one. Powderjet. Look them up, they're again on the internet. Gives you an idea of what type of entity you can create by spinning out a company. Imperial has an entity called Imperial Innovations, technology commercialization company that combines the activities of technology transfer, IP protection and licensing. And it says its goal is to build substantial, high quality, well-funded and well-managed businesses. That's interesting. Here we've got an academic institution that actually is thinking of itself as a business accelerator, effectively. Successful spin-outs from Imperial are CASA, which was a very, very successful process for treating allergies. Varian, which was to deal with vascular stents. Some very, very brilliant stuff that's come out of Imperial. But Imperial is much more commercial, in my experience, than either Oxford or Cambridge in how it develops the research. Cambridge Enterprises is the University of Cambridge model, and its objective is to help students and staff commercialise their expertise and ideas. And again, it's come up with some brilliant stuff: stem cell research, StepInGen, suspension technology for Formula 1 racing, Penske racing, software to give access to personal computer and change digital music, Duke Deck. The last one I think was very interesting: human genome DNA sequencing, Celexa. You can see straight away how all these different technologies are benefiting mankind. So it's a social contract model. So think about the very first few slides I showed you. They are creating something which is going to benefit mankind, whether it's to cure allergies, whether it's DNA sequencing. So what they've created needs to be protected through intellectual property. It's that social contract. They're not protecting it because it's a product of their personal representation of their human rights here. It's the social contract. They've done something for society, society rewards them by giving them a monopoly which only they can exploit for that period of time. Some interesting statistics there from Cambridge University which may or may not be of interest to you. I think this is quite interesting. Some more statistics from Cambridge. All this is public information. 141 new technology disclosures, 159 patent filings. So just a summary on IP issues. All universities have IP, but we need to be clear what IP we've got, who owns it, and what you can do with it. If you don't know what IP you've got, you can't do anything with it. If you've got some IP, you need to protect it to the best way you can so that you can do something with it. If you've got it, you need to value it. You've also got to work out who owns it. All these basic things. It's important to have balanced, I think, IP policies, because if you're going to be working together with a university or anyone, you need to have a team. And if there is huge unfairness on one side. It's actually because one party is getting a lot more money than the other party. To use my favourite industry, the music industry, the reason that most rock bands split up is not because they fall out with each other on personal issues. It's because they fall out with each other with who gets paid what from contribution to the songs. So why did the Beatles split? The Beatles didn't split because of Yoko Ono. The Beatles split because Lennon and McCartney between them couldn't agree who should get what from the song. They were listed Lennon and McCartney, but they weren't. And George Harrison got nothing because very few of his songs were used. Every time a major band splits up, it's because they're not getting a fair treatment on the copyrights. We've decided at the University of Cyprus to follow the Oxford approach on the IP policy, but we haven't decided anything on IP startups because we can't do it at the University of Cyprus. But when hopefully that law is changed and we are able to have startups here, we do need to decide how we're going to go about it and whether to follow the Cambridge model or the Oxford model or the Imperial model. When I was here in November, there were some fantastic speeches, and to me the best one was the one by the president. Was he a presidential commissioner who spoke?
The Minister of Internal Affairs? Or?
No, I think someone from the presidential office spoke. I can't remember his name, but what he said. It was Petridis, yes.
This is the Minister of Interior.
Is he Minister of Interior?
No.
What he said that I thought was very, very interesting was that everyone talks about, in Cyprus, about energy being the solution to all our economic problems and various other things. But he said it very clearly that innovation was going to be the way to come out of some of these difficulties, and I agree with him. You know, energy is finite. You know, in England we had the North Sea oil, and eventually they ran out of North Sea oil, so that was the end of Britain's oil business. And that will happen. If we find oil in Cyprus and gas, eventually it will run out. It's not a constant. Innovation, however, is a constant. You know, through mankind's history, people have always been creating and innovating, and always will do. So if we can harness that and use it in some way, and commercialise it, and put all the right bits in place to do this, then we have got a much better resource for Cyprus than I think oil and gas. Personally, I would say that, of course. But I'm not sure that at government level in Cyprus they have fully grasped this. It's easy to go and dig up an oil well somewhere, but it's not so obvious and easy to understand what you can do with IP. I personally believe that IP will solve a lot of the economic problems in Cyprus, but it needs someone to take the lead, and it needs an understanding generally of what you can do with IP. And I really hope that the university actually takes the lead and is able to do this, because you're the best placed organisation in Cyprus to do it. And hopefully everyone in this room will be part of it. And I'd like to be part of it too. Anyway, thank you very much for listening.